language to paragraph 4B, where it says in the second last sentence, if we terminate it, the parties shall have no further obligations to each other as expressly provided here to survive termination. I'm just going to add no further obligations to each other under this agreement.
Okay.
Except as expressly stated to survive termination. And that ties back into that additional language in 1B about adding that right to buy it if this goes south remains in case this is terminated.
Okay.
So then if we go to page 4, again in 4A, at the end, we had that same language about, at the second last line, it says, and the parties shall have no further obligations to each other. Add under this agreement, again clarifying that. And then also adding at the beginning, in all events and notwithstanding any other provision to the contrary, during the due diligence period and up until April 15th, 2022, the buyer, which is the district, has the right and its absolute and sole discretion to terminate the agreement for no reason or any reason. So that's that's part of in going to this transaction and conversations with Mr. DeSalvo and Mr. Organo is that the district has the ability up until April 15, 2022 to cancel. So that's why,
With a
and
full
we can do
refund.
whatever we want to do as far as due diligence and inspections. So the number of representations are relatively limited because it, again, reiterated that it's not for sale, it's not being marketed for sale. The district has an interest in buying it. That's why we're doing the transaction. If we go to page 4, the time frame, again, was 3 days notice, as we talked about before. If we go to page 5, again, that's been completely rewritten. That's with regards to getting copies of various documents, and it's been modified to provide for all plans, construction, remodeling, renovation, any engineering plans or construction plans for the property, and certificates of completion, certificates of occupancy. And we had a much broader section, and then Mr. DeSalvo in our conversation said, I have a whole bunch of documents I received from Lennar when I bought it. You will get those. And he said hard copies, Chuck? And then another company recently performed an evaluation. Is it Envirotech? I think was that the term? Yeah.
They were the ones that, yes, they were.
And that those documents will be provided by a Dropbox.
Okay.
And so that's what he mentioned. He said those are voluminous.
Okay.
And that no claims have been made against or threatened against him for the past 4 years, and that ties later on into the issue with regards to any slip and falls or hazardous waste or anything like that.
Okay.
So no claims have been made. Then we get into the next change that's on the, I'll call it the version that says latest edits 12/13/2021 at 5:36 p.m. We go to page 8 at the top. There's the, at page 8 at the, bear with me again. If we go to page 6, excuse me. Page 6, 7A, we added at the beginning, it says if buyer has not earlier exercised its right to terminate this agreement, subject to the following, then it will close. So that was added, as I noted in the green and yellow sheet. So if you go back to the top of page 8, Roman numeral 9, if you recall, in the yellow-green highlighted version, the seller struck that sentence out completely. And this has been modified. It says, seller shall deliver a duly executed attornment and estoppel according to the applicable lease provision from any third-party tenant of the property, duly executed in form for recordation. And what that means is we have Duffy's as a tenant. And typically in a transaction, the buyer wants to know and get an estoppel from the tenant that there are no outstanding issues, there are no claims, there's no claims against rent, there's no deductions from rent, and everything, the lease is in force and effect and everything like that. And that's then an attornment where the tenant says, I will attorn to and honor the buyer as my new landlord. So that's the tenant attornment and estoppel. And what the sellers wanted to make sure was that that would be provided according to the terms of the lease. There's specific lease terms in with Duffy's. We will get a copies of the lease, and we can look at it and determine whether the attornment and estoppel is satisfactory for the closing. So that's been modified, and that's acceptable. If we go to page 9, and that's representations and warranties of seller, let's see, this, 9, that language, no actions have been filed or threatened against seller in the past 4 years, was added earlier in the document.
Right.
We get to page 10, and on that page, there used to be a 9I and J, and they wanted it struck, and I was okay with it. It said, seller is not aware of any geologic subsidence or sinkhole activity within the property, and we thought that was a reasonable deletion. Seller is not aware of any protected or endangered wildlife species or habitat on this property, and I think that was, we deleted that in the green version, you'll see that. Now, there was a long, long paragraph with regards to hazardous substances or materials, and J is a substantially modified version of that. The seller said that they would represent that except for the mold which has been remediated, which we're all aware of. No notice has been provided to the seller and no claim has been made against seller concerning the property with regard to hazardous substances or wastes. And seller is not aware that any such claim is current or ever has been threatened during seller's ownership of the property. Initially, the hazardous substances section talked about to the seller's knowledge of belief, no third party has used, generated, manufactured, stored, or disposed of any hazardous substances, etc. And typically, if this was to be, I'll call it any other kind of site, that would be more appropriate, or even like a landscape maintenance facility, that would be appropriate to keep that in there because of the fertilizers, herbicides, pesticides, insecticides. However, this has been a restaurant the whole time, so that hazardous substances really is not necessarily appropriate. So we're comfortable with the, I'll call it the pared down language in there. And one other aspect is the seller has agreed to, and I'll find that section, to cooperate with regards to, it's called an ASTM Environmental Assessment Questionnaire,
Yes.
which would be part of any due diligence that the district performs. And I'll find that in a bit, but that's in the agreement. Let's see.
That was one of my original questions.
Yeah, let's see if I can, I'll find that text in just a minute.
It's section 4C, number 2.
Okay. 4C2, yes, thank you. Yeah, it said if they're requested by buyer, the seller shall complete an environmental screen questionnaire or cooperate in the preparation of an environmental screen questionnaire for an environmental due diligence for phase 1 and or phase 2. And for those, you all may be familiar with phase 1, phase 2 environmental audits. Phase 1 is, I'll call it an initial audit, environmental audit of property to see whether or not there might be hazardous substances or materials as defined by EPA on the property or within a certain radius of the property, looking for underground tanks, migration of diesel, oil, and substances, pollutants in or onto the property, and then from and what goes on in the property, what activities occur. And then if there is a concern or question that the property has some environmental hazardous substances, then there might be more comprehensive, I'll call it, and more invasive phase 2. Okay. So the seller has agreed to complete the screen questionnaire, and that will be our consultant to determine whether or not a phase 2 is necessary.
Okay.
So then if you go to page 11, 12, bear with me, and those have been already numbered. You go to page 12 of the version with yesterday's date at 5/36. Again, it just gives some clarification with regards to various warranties and representations as to the ability to, if there's any change in them, we, the buyer, have the opportunity to either waive or accept the material change or give the seller a chance to cure it, and otherwise we can just terminate it and get our deposit back. Initially, we had language in there, or comment before about whether or not to strike the language about surviving closing. We're been talking with other partners in my firm, we're okay because we have various representations that are made at closing that induce us to close, and so striking that language about these representations survive closing is okay.
Okay.
And one other aspect of this, and commercial transactions are different than residential. In residential transactions, there's a principle in the state of Florida, emanates from a case called Johnson v. Davis, that if you are the seller, and if you know or have reason to know of anything on the property that could impact its value or its habitability, the seller in a residential, non-commercial setting has an affirmative obligation to disclose that. Commercial transactions, it's between the parties. It's the old caveat emptor, it can be as is, where is, or you can have due diligence. But this one has a number of opportunities for the district to just terminate and say, give us our money back.
Okay.
For no reason or any reason. It may be a change of mind come May 1st, March 1st.
March 1st, yeah. May 1st, too late.
Okay, excuse me, March 1st. April 14th.
Yes.
Excuse me.
That's our last day to bail out.
And with these, and there was a reference to recording a memorandum of agreement. I put that in there, just sort of, okay, let's see what will happen, and I was not surprised when they said, let's strike that, because what happens when a memorandum of a sales contract gets recorded, it's of record and affects the title.
Oh, okay.
So if this contract were to be terminated, then the seller would say, I need to sell it to somebody else, and they couldn't while this recorded memorandums of record.
Okay.
So it's not unusual not to have it. The
Okay.
seller will look at that as a cloud upon the title.
Okay.
Chuck, do you have anything else to add to it, or Madam Chair?
I will say that having read these over numerous times, and I'm telling you that there's a little cumbersome, but I worked with Chuck and gotten emails from Carlton and with Tony. Thank you very much. They have been diligent in doing this, and having gone through this for the last month, I truly believe that this is a good contract to get us started looking at doing the due diligence to purchase the property. You've all gotten this, and I know looking at it, it's a lot. But I have great faith in Tony and his firm, and in Carlton, and in Chuck, who has dealt with Carlton and with Tony's firm before. And having gone through this and having a little bit of background in real estate and doing some of these things, I believe that this is a very good contract to get us started to look at the due diligence. So.
If any other questions for any board members? And at the appropriate time, if the board so inclined, would request that the board authorize the chair to sign the commercial contract for purchase with TAC in substantially final form, as indicated here, in case there are any other little changes other than what I noted. And I would request to be per the change made at the 5:36 p.m. December 13th version with the additions I mentioned today.
And I will assure the board, if there's anything other than what we had or anything substantial that would impact a change in this basic contract, I will not sign it. So I am not just going to throw us under the bus.
And I wouldn't do that either, nor would Chuck.
But I just want you to understand that this is, and I will say, this is a lot of responsibility. But I do feel that this is good even with these minor changes. Yes?
Eileen, thank you. I know there's a lot of legalese that has been discussed, but we had to wait until you encapsulated what this contract is or is not. I presumed, and you clarified, this contract is preliminary to a purchase and sale agreement.
Right, well, what this is going to do, this is going to allow us to do the due diligence.
I understand.
Okay.
I heard you say that twice. But my specific question is, the seller, as I remember at the last meeting, was very precise on a timeline. And so I think the timeline is you were going to make a decision today, and then by January you were to have some type of, I guess the bottom line, have we had the assessment of the value of that property done or completed as of now?
Madam Chair, if I could just make one comment. You're correct as to very precise timelines, and part of the timelines was have a letter of intent by a certain date, and then have draft contract by a certain date, and go back and forth with edits, and to have a purchase agreement signed by tomorrow. And this is the purchase agreement, is what's being considered. And in the purchase agreement, it provides for an appraisal. The appraisal valuation is not a contingency, but the district under the contract has the ability to terminate it for no reason or any reason.
Exactly. That's the bottom line that I wanted to hear.
Yes.
Because even though you sign a contract, and I know the lawyer has done a lot of preliminary work, if that appraisal does not come in to what the owner has expressed an interest on what they want to sell it for. So if the appraisal is substantially lower, I agree, or higher, we can back out of this agreement.
We can back out up until April 14th. Okay, so,
All right,
and get our deposit back, and yes.
I think the board knew that, but I think we as stakeholders needed a clarification, not only for the folks that are here, but for the folks that may be online, or what they may ask the board of directors at our meetings as to what the status. So I just, one person that wanted a bit of clarification, you've done it,
Okay.
and I thank you.
And I will, when I do my article for the next newsletter, will be stating in there that we've entered into this, we will be doing the due diligence and the appraisals and going through all of this. What I will be able to disseminate to the board, I will be able to, but based on his contract, there's a lot that I won't be able to do.
Understandable.
But yes, I will, the board will know whatever I can tell them, as will the residents, and I will update them in the newsletter as best I can with everything.
And I believe what you're unable to share is because of the sunshine laws. You have to be very, very circumspect
Yes,
as
and...
to what you present.
And the seller would rather not all the information be out in public. I believe that the tenant also does not want everything out and to be public, and that's why we've agreed that it would be Chuck, Tony, the appraiser, and myself. The rest of the board and the residents will get whatever information we can disseminate. And trust me, I am not throwing this community under the bus.
Well, thank you for that, all that clarification. I think we need to know that.
Chuck, Craig?
Can you tell me what the number the seller wants for the property? I haven't been at all.
$6,783,077.
Thank you.
You're welcome.
Have we paid in the 1% interest for the down payment or whatever you call it? 10%. I thought there was 1%.
No, you're correct about the amount. The initial
You
deposit.
haven't paid that.
No, that's correct. It's paid within 3 business days after the effective date. So assuming for sake of discussion that it's signed tomorrow, then 3 business days would be next Monday.
That
We-
The deposit would have to be provided by that time. Yes, sir.
If he gets an offer for 7 or 8, we decide to.
He can't, well,
Well, this does not preclude any backup contract on his part. That's the question.
Right. But we
You know,
will
which
get
is not
our...
unusual, and people have backup contracts that if this contract goes south.
You could change that number. 6, 7 is what he.
No, not once.
But if it's 8 million.
Not for us.
You can't go with the other.
No, once this contract is signed, then the price that the district would pay for it, if this contract were to go through to close, would be the $6,783,077. It would not change. But if this contract were to go away, and if he has a backup contract, well, that's his issue.
When does he have to sign that?
By tomorrow is the timeframe.
By tomorrow.
Tomorrow.
Both-
If he doesn't have an offer of, say, 8 million in his pocket today, he can't say, I won't sign it. I mean, he can't back out.
Oh, he can.
Oh, yeah.
We haven't signed it yet.
That's what I'm saying. If he has an offer, we don't know about it, and it's 8 million or whatever, he can say, no, everything is gone.
Right, but we will get our deposit back.
Well,
Yes,
what's
you know,
7,000? But,
I care.
I care. Okay.
I do.
I mean, we
I
got,
care also.
Yeah. So, yes,
so you've got to have some alternatives as to what you might want to do without Duffy's.
without that property, there's a...
Going to, what's the Richland's name? Market? Fairmont. and say, hey, we like the fire next door. That's not even.
We're hoping we don't have to
We
take
don't have to go that way, so
action.
let's work on this and take it from there.
That's step 2, this is step 1.
Because Santos, we still have a 7-year lease on the building, so whether.
With renewals.
Right.
There's some renewals in there, too.
Renewals. So whether we purchase the building or whether somebody else purchases it, we have a valid lease with renewals in place, so, we are covered. It's
With
not.
an option to extend it also.
Yes, we do.
At the new price.
Right. Okay. Any other questions? Okay. I need a motion from the board to accept this document with the minor changes that Mr. Pierce and TAC and Mr.
In
Gargano.
substantially final form.
Yeah,
Substantial.
substantial form. So I need
Make a motion.
A second.
all those in favor?
Aye.
Aye. Opposed? Okay.
Thank you very much.
Thank you.
Appreciate it. Well, it's the first step.
First step, yes. It's been a long step.
And part of it, Chuck has already engaged the services or contacted Carlton, he's already involved. And
Working on this.
There will of necessity be some other consultants that can work with the chair and Chuck on
Yeah,
for the other
to do
aspects of the
Okay.
environmental and some other aspects.
Did he say how long would it take? How long the appraisal would take?
Didn't,
I would expect probably, well, with the holidays, we're probably going to be looking later part of January.
Yeah.
it all depends on when the materials are provided to Carlton. I get the sense from Mr. Selva that once it's requested, he may have 30 days to give them, but I think he'll give them quickly. But
Okay.
if not, I think it's a 30-day. We have 15 days to get various documents, and then after the additional documents are 30 calendar days. So
Yeah.
by mid-January. So it might be February for the appraisal.
And as we go through this, if I get updates rather than waiting until the January meeting or the February meeting, I can do a brief synopsis and give it to Chuck, and then Chuck can get it out to you all so that you know where we are at different points with this process.
The appraisal amount is public, right?
It will
It's
be,
not part of
yes.
this other- It's not part of this other stuff?
That's not part of the sunshine.
Yeah, what won't be in there will be the documents that the
Yeah.
seller designates as being trade secrets, confidential, and
Yeah.
exempt.
Yeah.
But the document itself will be a public record. And again,
Yeah.
it's one of those oddities, when cities in Florida, counties in Florida, certain special districts in Florida, and the state buy, their appraisals are confidential and exempt, but not
Yeah.
for a CD.
Not for CDD. So,
Stepchild.
yeah. So it's been long.
No, it's just, again, it's the first step.
Just his first stop.
It's a first step. And thank you I appreciate the chair and Chuck's being responsive to all my requests.
Okay. Let's get to some mundane business here.
Yeah.
We have the unaudited financials for October, and I want to, I have spoken with Jeff Pinder, and thank you and he's been fine giving us these, and we will get the November statements the end of December, early January. They've been pretty dope. It really gives us a benchmark of where we are. The governmental funds are fine. I mean, this is the first month. The special assessment, the revenue bonds for the residents, we have 2 payments this year. Well, we've already paid the November payment. We just have 1 more in this tax bill, so we only have 3 more payments to make. The irrigation fund, we have paid back the money to the irrigation fund. They just owe us some money from the golf course and that's fine. The irrigation fund is doing fine. The golf fund, our cash balance as of last Friday was $149,631, which is, which sounds funny, $348 more than last year. But we have to understand that last year, included in the balance, was the $252,000 that we had borrowed from the irrigation fund that we have since paid back. So we are in far better shape this year than we were last year. And at this point, the only debts we have are the the bunker renovation and the bond, which are current, so that should help us substantially in obtaining a bond for the purchase of the property and for the road construction and for the landscape project. So Chuck will be working on that with the bond issuance and
Yep.
working on that. So, and Chuck, how long does that take?
Well, because you're going to have to go through validation, you're probably, and we can run some things in parallel, you're probably looking at 3 to 4 months.
Okay, so since,
Validations have been fairly quick to run through here in Lee County. They're still doing them by Zoom. They're
okay,
5 or 10 minutes on a Zoom call.
okay,
And it's, yeah, and because of that, they've been much quicker to get on the schedules, so.
okay, because we would need this by April.
Yeah, and what we may end up having to do is a bond anticipation note,
Okay.
Yeah, I would
just to bridge
anticipate,
the gap between,
A
you know,
and
when
B.
you need to pay the funds and when you could actually get your validated bond issued. So,
Okay.
yeah, I would assume that there would not be, the validation would not occur in time, nor in the appeal time run, because what happens is, the validation gets filed, coordinate with the state attorney's office, meet with them, get them to set the hearing date, advertise the hearing date, the rule of show cause hearing, and then assuming everything's fine and the court enters its final judgment of validation, there's a 30-day appeal time.
Okay,
There's only 2 times in Florida where you can have a direct appeal to the Florida Supreme Court. It's kind of interesting. Bond validations and death penalty impositions. So figure that one out.
death and taxes.
Death and
Yeah,
taxes,
death
I
and
guess.
taxes.
So I would not anticipate having this, a bond capable of being issued by April, more like June realistically.
Okay.
June, July, and that's what Chuck was talking, a bond anticipation note.
Okay.
Like a 1-year, maybe, 5-year.
I don't know, we'll see how the market is. They're anticipating the market to start to creep up, so
Yeah.
probably want to do the bond as quickly as possible, but
Yeah.
probably won't be timely enough to meet the April 15th.
Oh, no, it won't. In my opinion, it will not be.
okay,
So bond anticipation note? For
That's
how
what I'm
long? 1 year?
expecting. And we can probably do that through, I've actually got some private lenders that will pick that up,
Okay.
like
Okay.
Florida Community, well, Synovus now,
Okay.
Jim Mitchell. He did that for me over at Miramar, so.
First Horizon might also. I'll talk to you about
Nah,
that.
no,
They're
I
getting
don't like to work with them.
They're getting
They're
there.
not user-friendly.
okay. So we will be working on that, so, okay. Looking at the consolidated, the golf course, Jeff, you're way above budget, which is great.
Get the project description.
The concessions, I mean, the expenses, I mean, as of the end of October, we're $172,000 over budget, which is great. On the administrative, if we look down to the CAM, the lease and the additional $2,800 being paid to TAQ for the remediation, I have asked Jeff Pinder to move that to the building maintenance, so he will take care of that. So that was there. And on the concession expenses, the group insurance seems to be going to the, and it did last month, and what they're doing is they are going to, at this point in time, until we get down to the fine dollar amount, they're going to percentage it to John's group and to your group for the time being, so it's out of the concession.
Right, because
So-
no employees in concession currently have insurance benefits.
Right, but they're paying for everybody's, which is nice.
Jeff, is that payroll concession? Got something else in there?
That was the group insurance.
Tax, yeah, that's group insurance. That's everybody's.
Everybody's
John's,
insurance when you-
Mine, all our staff that's on insurance is all in payroll for some reason.
Okay.
So I spoke with Jeff Pinder, and they are percentaging out between the pro shop and John's group, so that should be taken care of. Jeff, there was one thing, what was that? Handicaps?
It's got to do with a gin golf, Golf Genius. All
Okay.
that's wrapped in there.
All right, we'll take care of that. I didn't have any other outstanding things. Does anybody else? We're doing well with paying off the revenue bonds, the golf course note for the bunkers. We only have 5 more payments, and that's on schedule. We have the money for that
I
budget.
have a question about that.
Yes.
So considering the fact that potentially, knock on wood, that we don't have any kind of disasters and we wind up with a surplus and a decent sized surplus, is it a good idea to go ahead and pay off like this $187,000 that we owe on these bunkers early? Would there be any kind of
There was no prepayment penalty on
prepayment
that.
penalty or no?
No.
Would it,
We could.
would it be a good idea or?
Let's wait till after season.
Yeah, I would hold on it right now.
Yeah, I'm just saying,
But
like,
there is no prepayment penalty. That was one of the things we wanted to make sure of in case we did have a great windfall and we had the money, we could do that.
Yeah, I was thinking, we never had really cash on hand. It'd be nice
Or-
to have a little something for just in case, right? And then-
Exactly.
or going back to the plan that we've talked about a couple times with, John, John's kind of nursing the greens along as we go here and like 2028, that would be the drop dead date to probably redo them, but if we could get a year or two ahead, if we could get, put a bond payment back that we could hold in reserve to pay out, so we could afford to be closed to be able to do the work that needs to be done. That's what I'm driving at.
Okay, well, we can look at it. Let's wait till after season to see how much money we
Yeah, like I
have.
said, knock on wood that we continue on this path, but if we do, that might not be a bad idea.
Because there are things we really need to, we're updating the community with the roads and the landscaping. Yeah, we need to start putting money aside for that.
Yeah, for everything, because you're gonna be closed for the greens, you might as well do your cart path work.
cart
Or try
path
to,
work.
once again, another big bond and do most of the,
Yeah,
infrastructure work. Bridges, can't forget about the bridges.
The bridges.
Gotta have them. Without them, especially on the front, you can't get by,
no,
I think that'd be more of a loan than a bond.
or loan, right.
alone, yeah.
Yeah.
So let's,
And also too, that building, back there in the shop, it's
it's seen better
30
days.
years old, we got the wash pad, it's original. It's doing fine, we're nursing it along, there's no issues there. I mean, the actual tank itself is, we've had to weld some pinholes that have happened, from, we're going to redo the roof on the chem room this year, we put that in the budget. But yeah, it's just time to think about some of the things we take for granted, that just are there.
And, we have plenty of time, but,
Right.
start looking at, what the cost of these are. And then, we can maybe put a couple in the budget next year and start.
Get an idea, yeah.
We can't really piecemeal the golf course greens and that would
Right,
be
definitely not
harder.
the greens.
But for the maintenance there, let's try and piecemeal and see if we can do this year and this. And so if you could get numbers down the road, that would be good. Okay. Can I have a motion to accept the financials?
I'll make a motion.
Second.
In favor? Opposed? Okay. Okay, the minutes for the last 2 meetings. I went through them. Mr. Huff will be glad that you were getting some ideas for that bunker.
Yeah.
I went through the October ones. I did not have any changes. Does anyone have any changes? Okay. Guys. No, I didn't have any changes in the October. You guys are okay? Can I have a motion to accept them?
Make a motion.
Second.
All in favor? Opposed? Now we go to the November ones. I didn't say they were pretty short meetings. This is going to be a longer one. And Chuck, for the January meeting, I'm going to invite Scott from Juniper. You're going to, Ms. Holmes from Johnson. She was going to come just in case you had any questions. Okay. I have no changes for November. Does anybody? No? Can I have a motion?
Motion.
Second.
All in favor?
Aye.
Okay. Tony, anything else?
Yeah, just briefly, at the last board meeting, we discussed the sidewalk easement to the village of Estero,
Yes.
and I revised the draft sidewalk easement and sent it out November 9th. I received it back, comments from Derek Rooney, the council, the village's attorney, and he doesn't have any objection to the revisions that were made in the board suggested revisions. And he said, I will leave the vegetation discussion up to David Willems, although it is certainly not our intention to reduce plantings, and so I've not heard anything more, I've not communicated with David, so I don't, again, it just is an interesting aside, when the contract with TAC references a sidewalk easement with the village of Estero, and I was having conversations with the seller and his attorney, their attorney, they mentioned this, I said, I'll send you what I've drafted. He said, okay. So that's the latest on that. That's
Okay,
all.
David Willems did call me, and I had that on my notes to say. He did call me the other day, I guess at the back gate here. They don't have the room to do the 10-foot wide sidewalk. So at this point, the village is undertaking the cost of putting the power lines underground for that section where they would need that. The one thing that they have asked us that in doing our common grounds landscaping, that we would consider doing that section in conjunction with them when they do that part of the road. And I said that when we get to that point, that we would also need the county, because in our August meeting, the county said that they would participate in redoing some of that. So, David, we had the discussion, I said I would bring it up at the meeting, discuss it. They're looking at hopefully having that done within the next 9 months. So I can talk to Scott Juniper about what we can do